So I want to welcome everybody tonight. My name's Patty Schramm, Parent Resource Trainer Coordinator for the SALT Talks. Last week, we talked about alternatives to guardianship, what's supported decision making, and that information. So I let Brittany know that we did talk about that, or we heard a presentation last week. I'm not sure if you knew Josh Young, but he's the one that presented on it. And so tonight we want to focus on guardianship. Just understanding it, what is guardianship and just the details of guardianship in general. And as Brittany presents, you can type your questions in the chat box, which is fine. She'll try to catch them, or I'll try to catch them for her. And then at the end, when we're done recording, I'll shut off the recording and we can do an open conversation as well. So I'm going to turn it over to you, Brittany, and let you introduce yourself and your information, and you're all set to share.
Thank you. Well, as Patty said, my name is Brittany O'Diam. Excuse me. I apologize for my very reflective glasses that I'm just realizing, man, this time of night, all the light reflects. So hopefully you guys, I don't look too odd for you on your screen. But as Patty said, I am an attorney. Our office is located in Centerville. I'm with O'Diam and Estess Law Group. We recently moved our office from Beaver Creek, where we'd been for the past 13, 14, 15 years or so. Over the summer, we moved to an office in Centerville just off of 675. So we serve basically the entire Miami Valley area. So we're working in multiple counties with clients largely in the probate arena. So we do a lot with the planning side of things, special needs planning and general estate planning through elder law, and a lot of focus on the processes that go through probate, whether that be estate administration after somebody passes away, or the guardianship process for individuals who need that as a resource. So a little bit about us. There are 3 attorneys at our firm, myself, my partner Kim Estess. We're both certified as specialists in this area, and then we also have an associate who just joined us over the summer, and she's learning all of this as well. So it's a good group that we have, and we really just enjoy this practice area. Bear with me for just a moment. I'm going to share my screen, and we have a PowerPoint presentation that we're going to go through together so that we can kind of walk through a little bit more about this. And my challenge here is that it is hard to do the PowerPoint presentation in presentation mode while sharing my screen. So tell me, Patty, if you can weigh in on this. Just seeing it in this view, are you able to see everything on there? Is it too big?
No, it's fine. It's great.
Okay. So while I'm in this mode, it is difficult for me to see the chat. So I'm going to have it up, but if I miss things, please, Patty, just jump in and interrupt me if needed.
Sure. Yeah, I'll catch you after that slide, probably.
Okay. So primarily what we're looking at tonight is basically, how do we create the best structure to allow someone to act on behalf of another person when that person needs the help, to help with their financial and their healthcare decision making, to the extent that they're not able to handle that on their own. And when we enter this conversation, there's really 2 main options that we look at from the get-go. And those options are powers of attorney and their guardianships. So our goal tonight is to talk through those options and identify more about, what is involved with each of those options. What are the basic guardianship rules, and how do those contrast and compare to how powers of attorney operate in Ohio? And then what myths and misunderstandings should we kind of dispel through this so that we can better understand how these options might apply to, your individual circumstances or things going on in each of your lives. So we're, from a big picture perspective, and you're going to hear me say this multiple times tonight, but the overarching theme here is the focus always needs to be on what is in the best interest of the person that we're planning for. Okay, so not always what's the easiest, not always what's, what your neighbor's cousin did, and so that's probably what you should do as well. We're always going to zero in on what is in the best interest of that individual, to make sure that they're not only protected and planned for, but also that we're not, unnecessarily impeding any independence that they have, and taking away things that they could do on their own, because this is not a one size fits all concept by any stretch of the imagination. So when we're looking at those best interest considerations, there's a couple main categories, I guess, that you could fold that into. The first being safety. What is the best care setting? We see this a lot of times come up when it comes to the challenge of, figuring out, is this an individual who can safely live at home with some support, or is it something where we might need a little bit more of a, group setting or an institutional setting, or, how can we safely structure the best care setting for them, but also why, not just because, again, this person's elderly, so they need to be here, or this person has this diagnosis, so they need to be here. We need to look at the why and look at the individual to figure out, what is ultimately going to match what their needs are. Within that, we're also looking at their well-being. So happiness and peace of mind and just overall quality of life are really, in my mind, just as important as their physical health. And I think we can all agree that it has a direct impact on their physical health. So making sure that we are protecting that and preserving that and enhancing that as much as we can really does need to be kind of at the forefront in all of these decisions. And then finally, looking at their independence. We don't want to do anything that is going to prematurely strip away any of their rights or their liberties to decide things for themselves if it's not necessary. Okay. So like I said before, it's not a one size fits all. The planning considerations and the actual plans that come into play here are as unique as a snowflake. I mean, every single family that we work with and every single person that we're planning for, their needs are going to be different. And so it's not just you need this, so this is exactly how it's going to work. We always want to tailor that to match that individual and that family and what needs to happen to protect their overall best interests. So to start, let's talk about powers of attorney. This is often kind of our first stop on evaluations. It is the less intrusive and less restrictive method of helping support, good decision making. And I know it sounds like Patty said you guys learned a little bit about powers of attorney and supported decision making. So I'll try not to belabor this too much, but I do think it's important to dig into because there's going to be a lot of references back to it when we're talking about the guardianship process. So having a good, comparison point is going to make, I think, the guardianship process make a little bit more sense in that. So in Ohio, there's really two main types of powers of attorney. We look at the financial power of attorney and the healthcare power of attorney. And I'm going to flip this on my screen here. I'm going to start with the healthcare power of attorney. So a healthcare power of attorney is just basically naming somebody to help make healthcare decisions for you if you're not able to on your own. So this is, anything from medications or surgeries or getting a second opinion or moving you to a different care facility or whatever you're able to do, they're able to basically stand in your shoes and make those decisions for you. For a healthcare power of attorney, the agent, the person that's appointed as the representative under this, is not able to override the wishes of the principal. Okay, so if I've nominated, my husband or somebody as my healthcare power of attorney, if I'm lucid and making decisions, he can't just say, no, that's a bad decision, I want to do this instead. It's a backup, if you will. Oftentimes you're going to see these paired with living wills. And in the grand context of an estate plan and all of the documents that come into play there, a living will is really the only document where we're not naming somebody to make a decision for you. So a living will is a directive from you to your physicians where you're making the decisions for yourself. And to boil it down simply, essentially what a living will says is if two physicians examine me and they determine there is nothing more that can be done to improve my condition because I am permanently unconscious or in a terminal condition, then at that point, I'm saying nobody else has to decide anything. So not even my healthcare power of attorney, nobody else has to decide anything. I've decided I don't want extraordinary measures, but I do want the comfort care. So don't keep me artificially alive, on a ventilator or something like that, but do give me the pain medicine and make sure that I'm kept comfortable. This often authorizes the withdrawal of artificially supplied nutrition and hydration, but only if that stops being comfort care. So generally they're going to continue to provide that as long as it's still providing comfort. But for many people in that situation, at some point it needs to be withdrawn. So essentially think of it as those really heavy end of life decisions that you're taking off of your loved one's shoulders, but really only when there's nothing else that can medically be done to change the circumstances. So that healthcare power of attorney and living will piece you'll often see paired together. On the other side of the coin, though, we have the decisions related to everything else. I should first of all make a point to note that healthcare decision-making documents, your healthcare power of attorney and your financial powers of attorney, are separate documents in Ohio. Okay, so you're not going to see those combined into one document. And sometimes we do see them that way. They're a lot harder to use and oftentimes can be kind of shot down as unenforceable in that context. So, where this is the route we're going, we want to have those in two separate documents. But on the financial powers of attorney side of the coin, essentially what you're doing is you're naming somebody to stand in your shoes and help just take care of things for you if you're not able to for yourself. So that's anything from, paying bills or dealing with real estate or dealing with bank accounts or getting your mail or, whatever comes up. You're saying this is who I trust to stand in my shoes and kind of handle that alongside of me. There's a few different types of powers of attorney. These are not one size fits all like we talked about earlier. These should be tailored to what you want it to actually do. So it's not just saying I have power of attorney, therefore I'm able to do anything under the sun. You are able, if you have power of attorney or you're acting as agent under somebody's power of attorney, you have the authority to do what the document says you have the authority to do. So we always have to look to the document and see what kind of power of attorney it is and what specifically it enables to be done. So as far as types of powers of attorney, you're going to look at durable powers of attorney or non-durable. We don't often see non-durable powers of attorney. What this means is a durable power of attorney means that it remains effective even if I become incompetent. So it doesn't terminate because I become incompetent. If it's non-durable, that would mean that it terminates when I become incompetent. Well, oftentimes that's kind of counterintuitive for how we're going to use these. So the presumption is that a power of attorney is durable unless there's a specific designation in it that it is non-durable. There's also springing versus immediate. Okay, so most powers of attorney that you're going to see are actually immediate powers of attorney, which mean that they become immediately effective as soon as I sign it. Okay, so if I'm signing a power of attorney right now that says, Patty is now my agent under my power of attorney, her authority under that document starts right then. Okay, and a springing power of attorney instead says, I'm naming Patty as my power of attorney, but only when this event happens. So it might be that Patty's my power of attorney, but only when 2 doctors have examined me and they've determined that I'm mentally incapacitated.
I got $200 shoes for $100.
And then, like I said, I'm sorry, the springing versus immediate, oftentimes we think of powers of attorney in the context of using them because somebody is incompetent. So springing might seem more logical, but too often, really more commonly, we're using them in context where it's not that somebody is incompetent or incapacitated, it's more that they're unavailable. Okay, so, as a young person, and when I turned 18 in my family, my father was an estate planning attorney. And so in our family, it was happy 18th birthday. Here's your estate plan, sign here. So, we signed our powers of attorney, we signed our healthcare directives, signed our wills and everything. And it wasn't because we had a fear of becoming incapacitated and needed to make sure somebody was there. It's that we know that there's lots of situations where you can become unavailable. So when I studied abroad in Switzerland during law school, my parents were able to use my power of attorney to help with things back home in my absence. My brother was, when he was in basic training, his identity was stolen, but we were able to use his power of attorney to correct all of that. He bought a truck remotely by power of attorney during his first deployment to Afghanistan. And during his second deployment to Afghanistan, we used his power of attorney to purchase a home for him. So he had a homecoming in the truest sense when he got home from that second deployment and moved in. We had moved him into this brand new house that he owned, but we were able to do that, all of that, because we had his power of attorney. So it wasn't that he was incapacitated, though as his little sister, I would say there's probably an argument there, but it wasn't that he was incapacitated, it was that he was unavailable, which is how we see this used a lot of times. It's a convenience, or it's a, I don't want to, or physically it's difficult for me to do that, so I'd like this person to be able to do this for me. And then we also look at general versus limited. A general power of attorney, you're thinking in that context, you're thinking, okay, well, I'm going to give them the broad authority to do anything that might come up. We still need to kind of spell out what those powers are. We can't just say I'm giving them the authority to do everything, but it is more general in nature. To contrast that, though, with limited powers of attorney, in that context, we're more looking at, I only want this person to have the authority to act in specific instances. So a lot of times you'll see those maybe in the context of real estate. I'm purchasing this piece of property, but I'm across the country, so I'm giving this person my limited power of attorney to act on my behalf to close on this purchase of real estate, or just to deal with the car title at the B&B or whatever that might be. So there's lots of different types of these, and lots of different ways to kind of mold them to match what your actual goals are. So as you can see, they can be pretty broad and pretty powerful, but they do have their limitations. So first and foremost, in order for a power of attorney to be valid, the person creating it has to have the requisite capacity to create it. So they have to be competent. They have to have a understanding of the impact of what they're doing, and understanding, yes, I want somebody to be able to help me with this, and I understand that this is the person I want to be able to help me with this. And the impact of signing this document means that I am giving this person the authority to act on my behalf and bind me to these things and deal with this without necessarily everything going through me first. So having the ability to understand and appreciate that is a requisite on both sides of the coin here. They also must be properly executed. So there are some formalities of execution that we have to go through in order to show that this is a valid document. And the reason for those formalities ties back to that first bullet point, because it's a way to provide some assurance that the individual executing this document does have the requisite capacity. Because if we've got witnesses involved, or if we've got notaries involved, then there's third parties there that are able to kind of have an eye on the situation and understand what's going on. And if there was a challenge later or any kind of question later, then we've got somebody that's able to provide more independent testimony as to the circumstances and the capacity of the principal. We also must have a person, an agent, who's willing to serve as agent. So just because you name somebody doesn't mean they have to do it, right? So I could name Patty and she could be like, no thanks, you've got a lot going on and I don't want to deal with it. So there has to be somebody that's willing to serve. And just because somebody has started to serve doesn't mean that they're tied into that role forever. So there's always the ability for somebody to resign or step down or whatever the case might be. So we always want to consider that at the forefront when we're creating these, and decide, should we name some backups just in case circumstances change and we need to switch to a different person. Financial institutions, this is a real fun one in Ohio. This is just the joy of my life, is that there's nothing in Ohio law that says that a financial institution has to accept your power of attorney. So even if it's a completely valid document, we've got valid execution, we've got an agent who's willing to act, and we have a person that was competent at the time that they executed it. If we take that into the bank doesn't necessarily have to honor it. So what that means is that every bank tends to set their own rules for when they will or will not accept a power of attorney. So it's a fun little game we play. They all kind of do it a little bit differently. Typically, the rules surrounding when they will or will not accept a power of attorney typically relate to the age of the document. So a lot of times you'll hear, oh, well, we can't accept this document because it was signed more than 10 years ago, more than 5 years ago. My record is we had a bank tell us that they couldn't accept a document because it had been signed more than 60 days ago, which was mind-boggling, but you know, they had the right to do that because there's nothing in Ohio law that says that they have to accept it. I actually redid a power of attorney today for a client because she had redone it. She had redone her really old power of attorney in August, but she hadn't put it on record with the bank yet. And she went to take it to the bank, and now here we are in February, so we're 6 months later, and we were 3 days short of that 6-month mark, and the bank said this document's more than 6 months old, so we have to redo it. So 6 months and 3 days later, we had to redo the entire document in order for them to accept it. So there's a little bit of a roll of the dice on that end. You know, so we want to try to beef them up and make sure that they're as protected or as enforceable as possible, you know, to make it more likely that banks will accept them when we need to. Another drawback or limitation on power of attorney is that there is no third-party oversight. Sometimes this is the benefit of a power of attorney, right? We don't have to go through, you know, a court process or, you know, extra hoops and stuff like that, like we would with guardianships, which we'll talk about. But that can also be a downside, you know, if there's nobody else kind of serving as a check and balance or, you know, providing some extra oversight. If you don't have the right people around you to help make this work, it can be kind of daunting. So having that accountability can be a piece that might, you know, not make this the best route. There's also often no method for determining incapacity or incompetency in the power of attorney context. So what that means, it really comes into play more so than ever when we are dealing with a situation where we need to override or overrule the principal's decision when it's a decision that was not made with the requisite capacity. Okay, so remember, I said most powers of attorney are immediate. That doesn't require that I be incompetent in order for my agent to act on my behalf. But it's also durable, which means that even if I do become incompetent, it continues to be effective. There's often kind of a shady gray area there. There's no, you know, definitive standard to say, okay, this is when this person becomes incompetent and can no longer make decisions, and we have to listen to the agent rather than the principal, okay? Because in Ohio, the only legally valid method of determining or declaring somebody incompetent, if you will, is through the guardianship process. So just having doctor's notes and things like that alone serve as evidence, but they're not necessarily dispositive of somebody's capacity. So where we see this come up a lot of times as an issue, I do a lot on the elder law side of things, where we're dealing with oftentimes living situations become our trickiest piece of the puzzle there. So, you know, if I have had a client who had pretty advanced dementia and was very unaware of her condition. So some clients with dementia are kind of aware of their limitations. She was not on that end of it. She was unaware of her limitations, had become prone to wandering and leaving, you know, the stove on or setting things on top of a hot stove. And there were a lot of issues going on that her family was very concerned about because it was a dangerous situation for her. And so they'd, you know, consulted with her doctors, and she wouldn't let in-home care come into her house. She threw everybody out because they were strangers and she didn't trust them, which understandable in her condition. So they were kind of at a crossroads that they needed to somehow protect her, but she wasn't going to allow it. Well, she had power of attorney. She had appointed her nephew as her agent. He had been helping her with things for years, and they had a very close and very, very positive relationship. And you know, he's trying to talk to her about why he thought she needed to move into an assisted living facility just to get a little bit of extra care and, you know, safety. And she was not having it. So when he did try to move her, the facility said, we can't force her to stay here because she's arguably competent to make her own decisions, even if it's not a good decision. And so even though they knew her diagnosis and they had the information from the doctors, they really weren't in a position where they could override her decision unless they had a court order that said so. So in that context where we had a good power of attorney document, we had an agent who was doing a wonderful job, and really, you know, they still had a very close-knit relationship even just despite this obstacle. We ended up still having to go through the guardianship process there, more so to enforce the power of attorney than anything, because we had to have a court say, this is the circumstance and we need to listen to this man now. So those are our major limitations when it comes to a power of attorney. So where those limitations become a kind of a factor that eliminates powers of attorney as a viable option, or terminates when powers of attorney can continue to be a viable option, that's when we kind of shift the conversation towards the guardianship process. We do use this as more of a last resort than anything, because it does involve a higher level of surrender of liberty and lack of independence and things like that, that if we can safely avoid that, we certainly prefer to, and the law prefers that. So when we're looking at this as a last resort, oftentimes it's because we've got an adult, so an individual over the age of 18 who is not competent, doesn't have the requisite capacity to sign a power of attorney document. So we can't even get over that threshold because they don't have that understanding and appreciation of the document and what its impact is. Or we need for involuntary institutionalization. That's that example I was giving you of, the woman who wasn't able to live safely in her home anymore, and her nephew knew that she needed to move to an assisted living facility, but it was going to need to be against her will because she wasn't able to make a good decision there, which really folds into the next one too, which is just basically the need to override the principal's bad decision. And enforce the better choice. Now, this is a very tricky point, and this is something that is really hard to deal with and we're constantly talking with families about this. When we have the capacity to make decisions, we are also allowed to make bad decisions. Okay, so just because a decision is bad doesn't mean that I'm incompetent. Okay, so I might not be making the best decision. I might not be reasoning through this in the same manner that I would have 20 years ago. But that doesn't necessarily in and of itself mean that I no longer have the capacity to make my own decisions. So it's a very, very fine line, and capacity itself is just such a tricky gray area that there's oftentimes a hard pill to swallow, that if an individual still has capacity, even if it's shaky, if they still have capacity to make decisions, then they're still entitled to make bad decisions. So we have to really examine that with a really fine-tuned microscope to make sure that we're not crossing a line into overriding somebody's decisions just because it seems to be bad. Other things that we look for when guardianships might need to become necessary, where power of attorney isn't going to suffice any longer, is where it's not necessarily the principal's ability, but also the circumstances surrounding the principal. So in this context, we might be looking at undue influence from a trusted person in their life who is kind of convincing them to do something that they really wouldn't have done if they were, making this decision of their own right previously, or if that person wasn't involved. We're going to see this in the context of abuse. We've seen, unfortunately, way too many people that were physically abused as a method of control. Exploitation, unfortunately, I think we've all heard about all of these scams and stuff that kind of run rampant and target people, vulnerable populations like developmentally disabled or the elderly, or whatever that context might be, that they're just trying to exploit some of those vulnerabilities in order to gain access to funds or to information or to whatever they need, whatever they're trying to take advantage of. So if somebody is just highly susceptible because of the state of their mental state, if they're highly susceptible to others taking advantage of them, then that might be a situation where we need to look more seriously into guardianship, where a power of attorney might not be quite as effective as we'd like it to be. Okay, so what are the options? So if we're going down this path, we're talking through the options, and we've decided, okay, maybe this isn't a situation where powers of attorney are going to be the route we need to go. So what other options do we have? When we're looking at the other side of the coin, you're looking at guardianships and conservatorships. I'm going to start with conservatorship. So this is the process of managing the person and or the estate of a mentally competent adult who just requests the assistance, okay? And they just want that probate court oversight, that supervision. So this is a very limited use because this is an individual who has mental capacity to make their own decisions, right? And one of those decisions they're making is, I would like for this person to be named as my conservator, and I would like for this process to be done through the probate court with this probate court supervision. Oftentimes you're going to see this in context of somebody who is more severely physically disabled, where they need a lot more hands-on assistance. Maybe they don't have the best personal structure around them, whether it be family or loved ones or close friends around to help support that. And so maybe having that probate court supervision is that missing piece that, having that third party oversight is going to be helpful to them so that they can make sure this is all being done the right way and that there's some accountability there. We very, very seldomly see conservatorships. I've never personally done one. We've evaluated them with a couple clients, and even the clients that have started to go down that path, for whatever reason, we've ended up going down a different one. So seldom used, but certainly can have a good place when it's appropriate. What we will more often see in this context when we're using the court processes is the guardianship process. So this is just the process of managing the person and or the estate of a minor or somebody who is mentally incompetent and is over the age of 18 or older, with probate court supervision. So we're going to dig into this process a lot more, but essentially what we're looking at is, the process of somebody who is applying to be the guardian. So applying to the court to become that person's guardian. And we must meet a couple requirements and cross a couple thresholds in order to get there, such as proving mental incapacity and proving that you're the best person for the job. Okay, so that's what we're going to get into now. So before we get into the nitty-gritty details, and I'm going to be using a couple terms, so I just want to make sure that we're clear on what these mean. So the ward, or the prospective ward, is the person for whom the guardianship is sought. Okay, so this is the individual who doesn't have the capacity, either due to age because they're a minor, or due to whatever other developmental disabilities or illnesses or anything like that might be going on that has rendered them incapacitated for the purposes of whatever we're looking at the guardianship for. So you'll hear this called the ward after a guardianship is in place, the prospective ward, while the guardianship is still kind of being evaluated. The applicant is the person that's applying to become the guardian for the prospective ward. And then the guardian is the person that is finally appointed by the court to take care of the ward with that oversight by the court on an ongoing basis. So when we're evaluating the guardianship, excuse me, I feel like I'm going to sneeze and I don't want to. Okay, I guess I'm not. When we're evaluating the guardianship process with families that we're working with, we always break it down into kind of four main questions that need to be answered. First and foremost is whether or not the ward is actually incompetent, whether they have or don't have the mental capacity to handle the issues that we're specifically talking about. Because if the answer to this is no, that they're not incompetent, they're competent, but they're making bad decisions, or they're competent, but maybe not the most in-depth thinkers, or whatever the case might be. If the ward is not incompetent, then the buck stops there. We don't move any further into the guardianship process, because that is the threshold issue that needs to be proven before we get on to these next questions. But assuming that we've established that somebody doesn't have that requisite capacity, the next insight here is whether or not there are less intrusive alternatives to guardianships that we could seek instead. Because like I said, guardianships do involve a lot more oversight, and they do involve, unfortunately, the stripping of some independent decision making and some liberties that these people would otherwise have outside of the guardianship. So we want to make sure that this is necessary, that there might not be something else that we could do instead that would be less intrusive, but still support that decision making in whatever context we need it. So going back to my story of my sweet lady that was not safe at home and really needed to be in that assisted living memory care setting, what we did when we applied for guardianship for her was we applied for guardianship. The nephew applied to be the guardian, and said, we want you to get to point number one. We want you to evaluate her capacity to make decisions based on this evidence that we've provided. But once you've determined, court, that she is incapacitated, when we get to point number two, is there a less intrusive alternative? Yes, there is. We have this power of attorney and it's working well, except for the fact that we need to override her decision. So rather than keep it as a full plenary guardianship, Your Honor, we'd instead like you to just basically put your stamp of approval and enforce this power of attorney so that the assisted living facility can rest assured that they have they have to listen to what the guardian is enforcing or deciding and all of that. So we didn't have to have a full guardianship for her. We were able to kick it back out to that power of attorney and make sure that we had his ability to continue acting in the way that his aunt wanted him to when she was of her right mind. The next option here, and I should say less intrusive alternative, sometimes you'll see that in the context of trusts that might be able to be used. You might see it in the context of, from a financial perspective, maybe stable accounts and things like that. So there's different ways to kind of craft this to make it work for what is best for that individual without necessarily throwing everything into the realm of guardianship, because there might be less intrusive ways to accomplish what we're trying to accomplish, and we just need the court's help to get there. The next issue that we look at is whether or not the applicant is the best person to serve as the guardian. Okay, so just because you're the one that applies doesn't mean that you're the best person for the job, right? Just because you're the parent or just because you're the sibling or whatever the case might be doesn't mean that you're necessarily the best person to help that prospective ward. So the court is always going to dig in deep on the applicant themselves and make sure of the relationship and the applicant's circumstances and the context of everything else that's going on to make sure that this is the best person for the job. This becomes especially important in contexts where we have competing applications. We might have more than one person apply to be the guardian, and even if the first two questions are easy to answer, this third one might be the tricky point, because now the court has to really decide which one is in the best interest of this prospective ward, who's the best person for the job. And then ultimately, as we've been talking about, everything ties back into what's ultimately in the best interest of this ward. Okay, if we've established they don't have the capacity, there's no less intrusive alternative, this applicant might be the best person, but in the big picture, is this in the best interest of this ward? Is there ways to limit it maybe further than what the application says, because that would be in the best interest? Or do we need to maybe even expand it because that would be in the best interest? So there's lots of ways to evaluate this to make sure that we're crafting it to what that individual needs. We've talked about incompetent. There's a difference between incompetence and incapacity. The Ohio Revised Code has a definition of incompetent in the guardianship statutes, which is why I keep going back to that word. I think incapacity is a little bit more, by definition, is more correct, more appropriate to use in this context. But a lot of times you will, you kind of hear them somewhat interchangeably. So Ohio law defines incompetency as any person who is so mentally impaired as a result of mental or physical illness or disability or mental retardation, or as a result of chronic substance abuse, that the person is incapable of taking proper care of that person's self or their property, or fails to provide for their family or people that they are charged by law to provide, or any person who is confined to a correctional institution within the state. So somebody who's in prison, for whatever term that they're in prison, they're considered to be incompetent for the purposes of guardianships. Somebody who, I don't like this definition, and I'll tell you why. I think it's overbroad, and we've come into issues with this in cases that we've had where we're actually representing the prospective ward that's saying, you know what, I'm not incompetent. I am physically disabled. I have limitations because of my physical disability, but that doesn't mean that I'm not mentally capable of making these decisions. And sometimes that physical disability might manifest as a mental incapacity because somebody's hard to understand or just has trouble communicating, but that doesn't necessarily mean that they are mentally incapacitated. So I really don't love that the Ohio definition of this includes physical illness or disability. It should really just be the focus on mental illness when it comes to that context, but that's my soapbox for the moment. But this is the criteria that we're using when we're trying to determine whether or not somebody meets that first threshold of incapacity or incompetence. And I mentioned a moment ago that physical disability doesn't necessarily mean somebody is mentally incapacitated. And so it's important to understand that the ward always has the right to prove the opposite, right? They have the right to prove, hey, I'm just fine. Remember, whose best interest we are looking out for. Our focus is 100% of the time on the ward or the prospective ward. And so if this is a person who is capable of making appropriate decisions, then they have the right to an attorney. They have the right to witnesses. They have the right to present evidence of their competence so that the court can weigh that in the context of everything that the applicant has presented, and the court can determine, you know, really what is the fact of the matter. So it's an important piece to keep in mind. So when we're looking at guardianship, like we've been talking about, it's not one size fits all. There's different types and there's different levels. And we have to kind of tailor this to the individual and figure out what type is the best. So at the highest level, at the most restrictive level, if you will, is an unlimited guardianship. You'll hear this called a plenary guardianship a lot of times. This is a full guardianship for all purposes under the sun of the person, of the estate, of everything that you can get out there. There are too many of these in cases where we don't necessarily need to have plenary guardianship. So we're always trying, certainly we do file these when it's appropriate, but we always try to work with the family to first kind of scale back and decide, okay, where can we, you know, limit this, and where can we chisel out some better definition here, rather than just saying for everything. So anytime that we can chisel out certain areas where this prospective ward is still capable of making their own decisions, that becomes a limited guardianship. So we're not saying it's unlimited for all purposes. We're saying we need a guardianship for these things, but we don't necessarily need it for these things. So I need a guardianship to determine, you know, living settings or care settings or things like that, but I'm still good to manage my own finances. I don't know, some things like that. So we try to tailor that however we need to. I want this person to still be able to vote. I want this person to still be able to drive, or I want all of these things for this person that I think that they're capable of, but they do need help on this side, and that's what we need to limit the guardianship to. Guardianship can be of the person and the estate. So guardianship of the person, you're looking at care and custody and healthcare decisions. Guardianship of the estate, you're looking at anything that they own. So whether that be money, whether that be real estate, business interests, things that they own. If they're not able to manage it on their own, that's when we're looking at the guardianship of the estate. So you might have it where it's person only, you might have it where it's estate only, or you might have a combination of the two. And then we look at emergency guardianships. And I will tell you, we get asked about these far more often than we actually file them. Emergency guardianships are for truly emergent situations where there is a immediate known risk of harm to this ward unless this guardianship is put into place right away. And the reason that these are so rarely used is because in order to get an emergency guardianship, we skip a lot of steps. We jump right to yes before we even have a hearing. So there has to be a pretty extreme circumstance before emergency guardianships are going to be appropriate. So even in situations that feel emergent, there's usually some some ways we can work through some of those emergent situations while we go through the full guardianship process, but certainly where emergencies exist, emergency guardianships can be really helpful. I've had several of those where this is exactly what needs to be done, and this is what the process is there for. What happens with an emergency guardianship is if I make an application to become somebody's emergency guardian, I still have to present some evidence and capacity and things like that. If the court accepts my application, then I am appointed as the emergency guardian for 3 days. So it's a 72-hour guardianship. And within that 72 hours, we have to have a guardianship hearing, an emergency guardianship hearing. So we're in court, not at the outset, but within 72 hours, we're there. And at that emergency guardianship hearing, I have to present on the emergency and explain, this is why we should skip all of the other steps and go forward with this. Same as in the other context, the ward gets to present information and things like that too. Other people get to present information. At that emergency guardianship hearing, what the court is deciding is whether to extend that 72-hour emergency guardianship for up to an additional 30 days. And at the end of that 30 days, basically we're having the full guardianship hearing. So that 30 days is the time that we use then to evaluate and file the full guardianship application so that the court can go through its normal process. But in that interim, we've got an emergency method of handling things. So where do we begin in all of this? Well, when we're sitting down with clients, the first thing we're talking about, if we've already determined that the guardianship process is the route we need to go for this individual, the first thing we're doing is determining what type of guardianship is actually needed. So figuring out where the limitations are, whether it's person, whether it's estate, whether it's both, whatever that might look like. Then we're going through and completing all of the forms. So there are a lot of forms. And in Ohio, we have 88 counties and we have 88 ways of handling the guardianship process, because every county has a probate court. And while the guardianship rules themselves are statewide, individual counties might have their own local forms or local processes, local rules that we have to comply with. So that's largely why I limit my guardianship practice just to these counties in the Miami Valley, because it's a lot to keep track of, what this court wants versus what this one wants. But essentially what you're looking at in the context of those forms is gathering information on the actual application itself. Many counties are going to have supplemental applications that need to be filed as well. So there's the application itself, but then there might be supplemental information sheets about the applicant. So here's more information about who I am and why I'm applying for this and my relationship with this prospective ward. And then more information, supplemental information forms about the prospective ward, just to give a little bit more insight and detail into what's going on with them. We also have to provide a statement of expert evaluation. So the statement of expert evaluation is a very key point to this. This is a key piece of evidence. It is not dispositive. So even if we have an expert that says this guardianship is necessary and this person is incapacitated, that doesn't mean that the judge has to agree with that. But they put a lot of weight on this statement of expert evaluation. So it's pretty in-depth form. Needs to be completed by a physician who has examined the ward within the previous 3 months. So there's a timing element there of making sure that this examination is timely and that we're dealing with statements from somebody who has the appropriate relationship and the appropriate insight into their condition and what's going on, and can give a qualified opinion as to whether or not that guardianship is needed. If we're looking at a guardianship of the estate where we're dealing with somebody else's property, then oftentimes we're going to have to post a bond. So the applicant has to basically be bonded by an insurance company up to double the value of the financial assets. So not double the value of real estate unless the real estate is sold, and then the bond would need to be increased. But we don't bond dirt, we bond money. So if I have a guardianship where the prospective ward owns $100,000 in different financial assets, I would need to show the court that I have qualified for this bond that is worth $200,000. And the point of that, the purpose there is to make sure that if that guardian doesn't do the right thing, and if they, shirk their duties or abscond with some of the ward's money, that the ward is still going to be made whole, and that we've got a way to make sure that they're protected beyond just what, the court would be able to do. The applicant has to go through a background check. So we help them through that process to get all of those forms submitted along with the application. We have to notify the prospective ward's next of kin. So these are their closest living relatives. Doesn't mean that they're necessarily the people that they're closest with, right? Because we all know that we're not necessarily, that's not how families always look. But if I have an individual who has two parents and one parent is applying to be the guardian, even if the other parent isn't part of that person's life, I still have to provide that notice. If they don't have parents, then we're looking at siblings and nieces and nephews and so on and so forth, and children and all of those kinds of things. So we do a little bit of digging on the family tree at the outset so that we can show that we have notified all of these people. And the purpose of that is to make sure that there's nobody else that might need to raise a red flag, right? Like, what if this is an applicant who is taking advantage of this prospective ward, and that this guardianship application is not really in this person's best interest because this person doesn't have their best interest at heart. Well, if there's other people around that might need to bring that to the notice of the court, then that's a way to make sure that they've been brought into the loop. And it's also because some of these people might have basically the equal right to become the guardian. So they might get this notification and decide, well, I think I'm better suited to do this, so I'm going to file a competing application. So we typically try to smooth all of that out before we're ever filing anything in the probate court. We try to have those conversations with the next of kin to make sure, we know what to expect when going through this process. There's not going to be any surprises, and that we really are looking out for the best interest of this prospective ward. And then just whatever else the court might require, drop of blood, lock of hair, whatever it might be. Different ones will require different things, but we don't file the application until we've got that whole package together. Okay, so we gather all of that, we file it at one time. That filing, that point of filing cannot happen until the prospective ward has actually turned 18 as well. So oftentimes I work with families with, children that are becoming adults that have developmental disabilities, which I know many of you have experience with. And we start that conversation maybe before the child turns 18, just to get all of our ducks in a row, and maybe have that full application process package ready to go, but we can't file it until that 18th birthday. So just as far as the timeline for that, that's something to keep in mind, that it can't be filed early, even if the hearing's going to happen, 2, 3, 4 weeks after the 18th birthday, we can't file it until that 18th. So when we file that whole application process, what happens? Well, we walk into the court, we hand it over to the clerk, or we file it online, depending on what county we're looking at. The clerk is going to come back to us with scheduling a hearing. So every guardianship is going to have a hearing, and this is the way for the court to get an extra pair of eyes on things, to make sure that they understand and that they can talk through any questions and have a chance to review the application and all of these supplemental materials and evaluate what needs to happen for this prospective ward. That hearing is always going to be a few weeks out. Depending on the county, it might be longer than that, depending on what their docket looks like. Certainly our smaller counties tend to get those hearings scheduled a little bit faster than the larger counties, but it all depends on what their docket's doing and kind of what their caseload looks like. The reason it's always at least a few weeks out is because between when we file the application and when the hearing occurs, the court is going to have its own investigator personally visit the prospective ward. And this is another instance of just trying to have another set of eyes on things and make sure that the court has its own understanding of the circumstances. It's also an opportunity for the court investigator to explain to the prospective ward what's happening. Okay, so make sure that they're aware an application has been filed. Answer any questions that they might have about guardianship, and if in the course of that conversation, they're saying, well, I don't think I need a guardianship, then that's when it's explained to them that they have the right to have an attorney and that the court would help them get an attorney, and they have the right to bring their own witnesses and all of that, just to make sure that they're fully understanding what's going on. Those visits are often as low key and easy on the prospective ward as they can possibly make them. So in the context of a guardianship for an adult child with developmental disabilities, oftentimes where it's pretty cut and dry that guardianship is going to be needed because of the diagnosis or the circumstances that's going on, the court investigators usually do a really good job of coordinating with the parents. Best opportunity to meet with this prospective ward, because they certainly don't want to upset them unnecessarily. They want to try to make that as pleasant as possible. And I have a couple friends that serve as court investigators, and they love it because they said it's the best time to, sometimes just sit down and get to know these people and kind of make some buddies out of it. So they have a good time with it, but they try to make it as comfortable as possible for that prospective ward. When we get to the actual guardianship hearing, the court does a really nice job across the board, across Ohio, of trying to make this more of an informal and casual circumstance. So it's not as intimidating as it would be if you were going in front of a judge in a criminal matter or in some sort of litigation context. Now, certainly there are situations within guardianships that don't lend themselves as nicely to being more informal and casual. If we have contested guardianships or competing applications or anything like that, it can certainly be less informal or less casual. But 9 times out of 10, it's going to be more of a conversation than it is anything else. The judge might start with asking some questions or have the attorney present some information, recap kind of what's in that application. But oftentimes what it lends itself to in most counties is the judge is going to start just by chatting with the applicant. Tell me more about, yourself. Tell me more about the prospective ward. Tell me more about, what's been going on and all of that. And just so the judge can have a good feel, or the magistrate can have a good feel of what's happening. Then they're going to have that same conversation with the prospective ward. If the prospective ward chooses to attend, they don't have to attend. I will tell you, with many of my developmentally disabled adult child clients, it's a cool experience for them. So, it's an opportunity to kind of see the courthouse and have a little bit of a different thing, and we end up having a lot of fun with it. So if that's appropriate, it can be a really cool experience. Some of them don't want to attend, and that's fine too. And they might have too much anxiety around it, or don't like the new place, new circumstances, new places, or things like that. That makes sense. So we choose kind of what makes sense for that person. But they're always going to have those conversations with both sides. And at the end of the day, the prospective ward always gets the last word. So if there's any kind of challenge, it always kind of ends on whatever the prospective ward has to say. The final decision is oftentimes going to be given right then and there at the hearing, especially if there's not a competing application or any kind of contest happening. If it's a pretty straightforward situation, then usually the judge will kind of explain, okay, here's where we go from here. I find that this person is mentally incapacitated, that there's no less intrusive alternative, that the applicant is the best person for the job, and that this is in the best interest of the ward. So I'm going to accept this application, and then they will issue what are called letters of authority right then and there, so that you can then use those going forward to show your proof of guardianship, essentially. Sometimes if they're not at that point, if there's more information that's needed, they might order further expert evaluations. We'd like you to undergo an evaluation by this court-appointed therapist or physician or whatever that might be, and we'd like them to report back, or whatever additional evidence the court might need in order to make that decision. But we don't see that come up as often if there's not a competing application or some kind of contested issue. So what happens then, right? Okay, so if we've gone through the hearing, we've been appointed guardian, we have our letters of guardianship showing that I have the authority to do that. There are education requirements. So Ohio law requires a 6-hour initial course for guardians, and then 3 hours of ongoing annual education. These are offered online, they're offered for free, they're offered in person, different places as well. So they try to make them pretty widely available. What you'll find a lot of times in guardianships where the parent is the applicant of guardianship over a developmentally disabled adult child, a lot of times the court will grant our request to defer the education requirement. So what that means is they're not waiving it. They're not saying you never have to do this. They're saying, basically you don't have to do the 6 hours and you don't have to do the ongoing 3 hours every year, as long as you keep doing what you're supposed to be doing. So as long as you keep complying with the continued reporting requirements and that everything continues to go smoothly with the prospective ward, then we're not going to require that you go through this education. But if there are missteps or mishaps along the way, then they might say, okay, you know what, we're lifting that deferral and we need you to go complete that education, because that might be information that you're lacking and would help make things go more smoothly going forward. There are continued reporting that needs to happen after guardianship is instituted. So if we have a guardianship of the estate, then we're going to need to file an inventory with the court after the guardianship is instituted. We're going to need to file an inventory within the first couple months showing here's exactly what the ward owns and where it's located. And a lot of times then we're going to be moving, if there's financial assets, we're moving and shifting those into guardianship accounts and into the name of the guardianship so that the financial institution understands who has the authority to manage those assets on behalf of the ward. But we're asking the court for permission for every step of that along the way. On a guardianship of the estate, there's also accountings that are due. And this is to just show the court, okay, here's where we started, here's where we ended at the end of this accounting period, and here's what happened every step along the way. So down to the penny, we're saying here's what came in and here's what came out and here's why. One thing to keep in mind is when it comes to here's what came out, when the court's reviewing those accountings, they're going back through their own docket and making sure that the guardian asked permission before all of those things came out. So once that guardianship of the estate is instituted, if there are funds that need to be used by the guardian for the ward, then we can only use those if the court has given its okay in advance. So oftentimes at the beginning of a guardianship of the estate, we are submitting a request for ongoing disbursements to say, okay, here's their annual or here's their regular monthly expenses, or here's things that we know are coming up, and we'll just ask their advance permission to just keep doing this. And then we only have to go back when there's extraordinary things that come up that are different than what those ongoing expenses might look like. So it can be daunting to think about, but we try to make it as streamlined and smooth as possible. But the court does want to make sure that that accounting at the end of the day matches what those disbursement requests were, so that everything was done on the up and up. We have guardianship plans that are filed on an annual basis just to show, hey, here's kind of what I'm thinking. There's a court form that we use for this to show, that the guardian is paying attention to what's in the best interest of the ward and has, proactively planned for how those best interests are going to be met. There's guardianship reports to say, okay, here's what our plan was. Here's a report of how that plan actually played out. I will tell you on some of these reports, different counties will have different reporting periods. So I believe that the structure is that they can do it every year. Many courts choose to do it every 2 years. So that's something that we have to kind of look at as we're dealing with county specific rules, to know that we're doing what they're requesting and not just guessing across the board. Those are the bulk of our ongoing reporting and ongoing education requirements. Oops, sorry, going too far. Another thing to think about, in the context of many of you who are parents of individuals with disabilities, is making sure that your plan is also in place. So it's easy to think, because you're a parent, it's easy to focus so intently on your child and what they need that it's, you might forget about what you need. But having a plan for you as the caregiver is really just as important as making sure we have a good plan in place for the individual with disabilities. Because if something should happen to you, we need to make sure that your plan is set up to make sure that they're taken care of as well. So it's a perpetuation of what you've been doing your whole life, and making sure that we have the right structure there, whether it be special needs trusts or powers of attorney and healthcare directives for you, whether it's insurance, life insurance, to make sure that there's money there to provide for what this individual might need if I'm not here and earning money to help with this, or whatever that might look like. Nominating who your successors should be. If you're the guardian, you have the opportunity to let the court know, hey, if I'm not here and able to do this, here's who I think is best suited to be next in line. Now, it's not dispositive. The court's still going to have a hearing on it, but they put a lot of weight on what those nominations are. So something to be thinking through is just how your plan impacts your loved one and what structure we might need to be putting in place to make sure that this caregiving can continue even if you're not able to provide that care yourself. And like I said, at the end of the day, it's about just making sure that somebody is there to help you so that you're able to help them, and that everybody has what they need to be well cared for in any circumstance. All right, that's a lot of talking. I think I've gone over by a few minutes, which I always do. So Patty's pretty used to it, and I know I talk fast. So I want to hear from you what questions anybody has. So Patty, I'll let you take the floor. I'm going to stop sharing so I can see people's faces a little bit easier if people do have questions.
Okay. And I'm going to go ahead and stop the recording so that we can have open discussion on this, because it was a lot of information. Thank you again, Brittany. And I'm going to go ahead and stop the recording 1 second.